Hello everyone! In today's discussion, we will discuss about the principal cases. I am Precious Chardy and Rana, and together with my group mates, Rusty Suerte, Kaina Saberon, Ralph Michael Orsabia, and Lawrence Dave Kilope, and last is Christian Rial. So let's start. We have here learning objectives. So at the end of this lesson, the learners should be able to first explain the principal cases. Second, aims to demonstrate the features of a judgment. Last is discuss the principal cases and the courts. Introduction. The common law is based on cases recorded in England and Wales, and the law reports in All England Reports or AER, and in Scotland, the Session Cases or SC and Scot Law Times or SLT. It is based on the doctrine of precedent, under which in vast majority cases a court must follow the earlier decisions of the courts as its own level, and of a superior courts that is known as binding precedent. The doctrine of binding precedent is called stare decisis, which means keep to the decisions of part cases. So it means that this stare decisis is a legal doctrine that obligates courts to follow historical cases when making a similar case. It binds courts to follow legal precedents set by previous decisions. From the word bind, it's like integrate, and precedent is a principle or rule established in a previous legal case. So this is all about the legal rule or a principle articulated by an appellate court, the decision made by higher courts and must be followed by lower courts within its jurisdiction. So for the doctrine of judicial precedent to operate, it is necessary to know first the legal principle involved in a particular judgment or ratio decidendi, and second, when it's persuasive. So it is involved an application of the principle of stare decisis to stand by the decided. In practice, this means that inferior courts are bound to apply the legal principles set down by superior courts in earlier cases. This provides consistency and predictability in the law. So let's proceed to the features of judgment. First is ratio decidendi. What is ratio decidendi? This means the reason for deciding, and is the legal principles behind a particular judgment, the actual finding on a particular fact that is a proposition of law that decided the case in the like, or in the context of the martial facts. It is a judgment that based on the principle of law that formulated by the judge for deciding the problem. It is a rule of law on which a judicial decision is based. Refers to the legal, moral, political, and social principles on which a court's decision rests. It is the rationale for reaching this decision case. So the example of this is the case of Donoghu v. Stevenson, 1932, and later on my co-reporters will discuss. So for next is obiter dicta. What is obiter dicta? These are the comments by the way, such as a reference to what could have happened had the facts been different, or reference to an aspect of law that may not be specifically relevant to the case. These are the observation made by a judge in an opinion that is not necessary to resolve the case, and it is not legally binding on the other courts, but may still be cited as persuasive authority on future litigation. All other statements about the law and the text of a court opinion or pronouncement that do not form a part of the court's ruling on the issues actually decided in that particular case whether there are correct statements of law or not are obiter dicta, and are not rules for which that particular case stands. The obiter dicta can also help in the growth of law. This sometimes help the cause of the reform of the law by observations. Those cases that many people affected but not given a chance or to take an action to that matter.
This principle is that one must take reasonable care to avoid acts or omission that could reasonably be foreseen as likely to injure one's neighbor. So this principle, you need to be careful and kailangan mo makipag-associate with other colleagues, and also as a worker, you must also check the product before display ito, because hindi ikaw ang nakakasama but also to the customer, and if you let your customer have something bad happen to him, you are not only responsible but also your workplace. It is important to provide a secure working environment, especially a secure entrance and fire exit. Example nito is kung may mangyari mang aksidente sa iyong pinagtatrabuhan, it's very important to have a fire exit so that all of you can easily go outside to avoid the accident. It is also important that your equipments and appliances are clean and safe in order to ensure the safety of products, which you should check on a regular basis, kasi kung malinis at safe lahat ng gamit nyo, it can prevent accident, and also you can make a good and safe product to offer. It's important to keep a work system in place. So as a worker, you should always double check the equipments or materials you use to create the products in your workplace. For example, before doing the job, just always check the equipments if there is damage, because it will cause some other damages in your workplace so that the work will be delayed. It is important to assign a qualified worker to the job, because having employees who are unfamiliar with the work in your company or in business can result in accident. Example nito is, you are the worker na hindi alam kung paano gamitin ang mga equipments at walang pake sa safety ng iyong workplace, magkakakos ito ng accident not only to your workplace but also to your customers. Reasonably practicable is a legal requirements. It means doing what you are reasonably able to do to ensure the health and safety of workers and other like volunteers and visitors. For example, is nandun ka sa isang ginagawang building at bago pumasok, kailangan dapat may mag-orient na isang eksperto o may magpaliwanag sa mga gamit na nandoon upang maiwasan ang aksidente sa lugar. Is a high degree of risk of death or serious major injury. A safety precaution that are not taken where the duty is considered very important. Duties on employers may be absolute or strict. In this case, the duty is qualified by a term shall or must. For example, the management of health and safety at work regulation place an absolute duty on every employers, though every employer shall make and give effect such arrangement as are appropriate, having regards to the nature of his activities and the size of his undertaking, for the effective planning, organization, control, monitoring, and review of a preventive and protective measure.
Paris v. Stepney Bureau Council, 1951, AC 367, the duty of care and the standard of care onto vulnerable person. The defendant showed in evidence that it was not standard practice to provide eye protection for activities of this nature, at least where employees had too good eyes. Thus, an employer may own a higher duty of care to an incapacitated employee than does an employee who is fit and has all faculties. So in this case, involving one-eye workman employee in the vehicle maintenance. So while hammering a metal particle, he accidentally hits his eyes and resulting in total blindness. Latimer v. AEC Ltd. 1952, 2 EAR 449. The practicability of precautions and unreasonable precaution. In this case, the practicability of precaution was seen as appropriate in the circumstances. In the Court of Appeal, the point was put by Denny L.J. Thus, it is a matter of balancing the risk against the measures necessary to eliminate it. In this situation, the cost to the defendant was too great in relation to the degree of harm that could occur. Have the balance the cost of taking precautions against the risk of injury. So Irs8 v. K&L Steel Founder and Engineers Ltd. 1953, 1 ER 97 and 2 AER 320. So the duties of employees with regard to dust and fumes control and practicable precautions. So the various cases have hinged on two conditions of this section, namely the dust or fumes or other impurity as to be likely to be injurious or offensive to the person employed. The second one is a substantial quantity of dust of any kind. So where either of the conditions is full, the occupied is under a duty to take the practicable measures detailed in the latter part of the section. So the measures must be possible in the light of current knowledge and invention of the time. So Marshall B. Gotham Co. Ltd. 1954, 1 AR 937. Practicable and reasonable practicable. So in this case, the two levels of that is those of a practicable and reasonable. Practicable nature were compared as a means lives have been at stake. It should not lightly be held that the take practicable precaution is unreasonable. Richard Thomas and Baldwin v. Cummings, 1955. Emotion and use of relation to machinery. So this case involved machinery fencing requirements under the FA and the actual interpretation of machinery. In motion or use, the phrase includes motion or use in the mode of manner in which is the machine operate and for the purpose for which it was used, not merely movement of any kind, and does not include memory of the parts by hand in the case of a power-driven machine.
We are now on the topic 13, and by the way, I am Ralph Michael Orsambia, and this is the continuation of the principal cases. Davy v. New Metron Board Mills and others, 1958, 1 AER 67, or the defective work equipment. The plaintiff was employed by the defendants on a machine. When in use, the drift had to be struck with hammer. The plaintiff had to obtain a new drift from his employers, and although it appeared to be nearly new, at the second stroke of hammer, the drift shattered and a piece of metal struck him in his eye, causing him lose the sight of the eye. It was held that the employers had used reasonable care and skill in providing the tool and were not liable the plaintiff for the injury. So when we are in a job, we must use those safety gears that will protect us to avoid injury. So also, a man in a work should know what he is doing, and that was the prevention for the accident or the injury that will may happen. We must be prepared and aware what is going on our workplace. Wooding v. Associated Portland Cement Manufacturers Ltd. 1965 1AR213 or the dangerous machinery disregard of danger and contributory negligence. The plaintiff was employed as a machine minder in the packing plant in a cement factory. He attempted to catch a pigeon. He leaned across a revolving shaft that is thus extraction equipment in a place which he was not authorized to be, losing his arm as a result. He thought an action for damages against his employer, alleging that the shaft was dangerous part of machinery that should be fenced in accordance with Section 14, page 1 of FA 1937. It was raised and held in a court of appeal. So this was a discussion what happened, and these are the aspects that the employer should be responsible. So first we have was performing an act wholly outside the scope of his employment. Second, for his own benefit. And lastly, at a place to which he knew he was not authorized to go. So as we go back to the case said that a man or the plaintiff is trying to catch a pigeon, and suddenly the accident will happen and he loses his arm. So in that case, that was what we call for his own benefit or outside of his job. So therefore, the responsibility was appointed on basis of 20% to the defendants and 80% to the plaintiff. John Summers and Sons Ltd. v. Frost 1955 1 AER 870 or the absolute duty to ensure secure fencing of machinery, reasonable foreseeability, and breach of statutory duty. The respondent was employed by the appellants of the steelworks as a maintenance fitter. While grinding a piece of metal on a power-driven grinder, he was injured when his thumb came into contact with the revolving grindstone. The machine was fitted with an efficient guard and the only part of the revolving grindstone. It was held by the House of Lords that as the grindstone was dangerous part of machinery within Section 14, page 1 of the FA 1937. There was an absolute obligation that should be in offense to prevent such injury as reasonably foreseeable. In this case, machine was not securely fenced, with the outcome of machine would render it unusable. So in this case, as we interpret this, the machine are not fenced securely. So that's why there are injuries happen or accident happen, like this man, he injured his thumb due to lack of fencing those machineries that will cause the injury to a worker. So as the court appeal, we all know that the injuries or the accidents is not foreseeable. So that's why we should be prepared and aware. We should fence those machineries that can cause injuries, and we don't know what accident may happen, but for sure we are aware and prepared on what happened. Kilogalan v. Coke Incorporated Ltd. 1956 1 AER 294 or the breach statutory duty and the double-barreled action. This case involved the fencing requirements for machinery under FA 1937. There are 8 injuries employee due to failure to comply the fencing requirements. It should be noted that this legal right of an injured party to take double-barreled action was the extent excluded as a result of Section 47 of the HSWA. So in the workplace, we should be prepared, we should be settled or our all tools or equipments so that we should avoid those accidents or injuries that may happen. So in this case, it involves the failure to comply the fencing requirements. So that's why it is under the FA 1937 said that all machinery should be guarded or should be fenced to minimize or to avoid those accidents or injuries for the workers or employee that may happen. We are now on the topic 18. Close v. Steel Company of Wales Ltd 1961 to AER 953, the breach of statutory duty. The appellant was operating an electric drilling machine when the drill bit shattered and piece struck in his eye. He claimed the damages. It was held by the House of Lords that first, the respondents were not in a breach of duty under the section because the drill is not foreseeable danger as the section required. Next, the duty to fence dangerous parts of machinery as required. And lastly, the obligation was to fence the machinery and not to prevent fragments to the material being worked and from flying out the machine. Lastly, the factory should have the absence of guard to protect them may injured person a cause of action at common law. So as we said earlier, that we should fence all the machineries that we will use in the work, and also we should be prepared and aware that we have these safety equipments and safety gears that would protect us to danger or harm in some cases. So all should have a claim responsibility, the owner and also the worker, that worker should do his responsibility on or do his part as a worker and to prevent the injuries. Also, the company should neutralize their workers that those machineries or the equipments are safety to use for their workers. So all of these cases or all of these principal cases is appointed in the Court of Appeal. That's why the health safety management is working their job to solve or give solution for these cases to avoid the injuries and accident in the workplace.
Irs8 v. Coventry Corporation. The times April 22, 1969. Due diligence under the ORSPA 1963 and cleaning of machinery by young people. A bacon slicer was used by the staff at one of Jewer's shop in Coventry. There were only 2 employees, a manager and a boy aged 16. The machine was manually operated by turning a handle that caused the cutting blade to clean the machine properly. It transpired that there were 2 ways of cleaning the blade, either by removing the blade from the machine and wiping it. Second, by cleaning it in position by drawing a cloth across half the blade and then turning the handle to expose the other half and wiping it. And the company was prosecuted and convicted for a breach of Section 8(1) of it ORSPA. So, while may dalawa ka employees, manager and 16 years old na lalaki. Then while limpyo ang katong 16 years old rin na employee, wala ang manager pero wala enough na knowledge ang katong ang lalaki sa paano paano ang way sa paglimpyo sa katong sa machine. Then galing din siya na galaw niya ang katong pang-on sa machine. Din ang katong blade na start o tuyok. Then ang na while tuyok tong blade na igo ang kamot sa lalaki or yung finger dito sa blade, and katong tips yung finger kay naputol. Then na relate murag gyud ni siya katong last topic ko na to negligence to sa isa ka classroom kanibal na accident itong student. Then ang teacher pasan gyud sa teacher ang may kabugo dito kay siyempre nasi ang trabaho kay bisag maun sa mga bata kay saya gyapon maduol. So atong naitabo diri while nangyari to na situation tong pagputol sa kamot sa lalaki, ako sa manager ang katong saya kay syempre di ba siya manager, so dapat kailangan niya i-monitor ang katong unsa mga ginahimo sa iyang mga employee kung tama ba dili or ang safety gud nila. So tungod ato ang the company was prosecuted and convicted for a breach of Section 19 of it or SPA. So murag nakasuhan gud sila or kung katong manager kay siya ang nakakaano sa sala, siya ang tugos kay syempre ang bata wala mo siya enough na knowledge siya dito na bagay. So as a manager po need niya to i-face na responsibilities kay in order para dili to may tabo na situation dapat i-guide to niya ang bata. So next is Mr. V. Romford, Ice and Cold Storage Ltd. 1957 1 AER 125, a vicarious liability, the duty to non-employee and breach of contract. So this case involved a lorry driver employed by the defendant who negligently reversed the company's vehicle into another employee, which is his father. This employee was awarded damages to be paid by the company under the doctrine vicarious liability. The defendant held insurance cover for this form of liability, and the insurance company paid the damages. The insurance company subsequently sued the lorry driver in the name of the company to recover what they had paid. So in this situation, naitabo diri kay may isa ka lorry driver which is employee sa isa ka company, din gipagamit niya ang iyang car sa relatives niya which is yung papa. Then while ginagamit sa iyang papa ang car kay na accident. Then parang nakabalo ang company, tos ang gihimo sa company is nasa way na vicarious liability. Like ang vicarious liability kay halimbawa ako tong employee, din gipairam na ako tong ang car sa company na ginagamit na ako, tapos gipairam na ako sa akong papa din. Yung ginagamit to sa akong papa na siya na accident. Then ang kato na situation kay parang bayaran ako tong akong car kay tubuson ako to na ako would mag-face ato sa consequence, like di ba employee mo na sa isang company din. Ang kato limbawa mabayaran ako to siya sa in a way na kanang ang nakasala kay tubuson ako din ang katong ang accident na car which is ang car sa company kay bayaran ako in a way na akong sweldo kay dito ka onward. Like kalimba sa sa 3 months like dili ko magkuha sa akong sweldo kay ang katong sweldo nako kay moto akong ipanganagod ako may pangbayad sa na-accident na car kay vicarious liability kalimba kato gani na relatives na ko ang nakasala, tapos ang katong gigamit na car is dili pag ako din sa company. Then ang naka-accident din ba kay relatives na ko, so kato ang naka-accident kay relatives na ako din ako employee ko. So kato, in order for that na matapos ko na situation or maharap ko na consequence kay example kato sa 3 months dili na ko bayaran ng car, pero ang sweldo nako mo to ko'y pangbayad para ma-okay to na good na situation. So kato, next case is White Bay Press Steel Fisher Ltd 1980 IRLR 176, the training of trade union safety representatives. Under Section 2(c) of the HSWA, an employer must provide information, instruction, and training for their employees. Thus, the training of safety representatives must be viewed by employers as being different to that required for other trade union officials who, by virtue of Section 27 of the EPCA, must be approved by the TUC. So in this case, talks about before ka dapat mag-provide ng mga employees sa company na ilang gina-applyan sa ilang information, and dapat na sila enough training para ma-qualify to the bar na company sa information kay need siya kay para halimbawa kailangan kilalanon sa company kung kinsa tong employee kay kung okay ba ang health niya or wala ba siya sakit or wala ba bad na background sa siyang life, and sa enough training kay para maabot ko naman expectation sa company, and mas good employees na para mga representatives sa mga iba-iba good na field, like pwede nila ipadala sa iba na companies kay ang ina nakuha kay good may enough knowledge and mas mag-excel pag dito na bagay. And also sa information, di ba, need nila makilala and makabalo kung may mga sakit ba or dili. Kaya ba gatrabaho ka tong employee na natawat na siya kalit lang na nag-collapse good. So mas madagdagan pa ilang trabaho na managod na sa company matake nila kay, di ba, ang mga employee kay sakop mo na nila ganun. Halimbawa kung may tabo dira, so sila yung pa ng di ba, ang mabad image. So kato dapat before sila gakuha o mga employee nila para sa company, need nila enough information, instruction, and proper training. So kato. So next case is Thompson, Gray, Nicholson v. Smith, Ship Repairers, North Shields, Ltd. 1994, IRLR 932116, Occupational Deafness and the apportionment of liability. This is one of several cases involving a claim for occupational deafness by an employee who had been exposed to noise in a number of former employments. Former cases had established the view that the last employer was specifically liable for damages. The outcome of this case is the tendency of the courts to apportion liability between the various employers, all of whom, through exposing the individual to various levels of noise, have contributed to hearing loss and subsequently occupational deafness. So, in this case lang sa isa ka company good na may isa ka employee na nawala gud ang iyang hearing, and while gatrabaho siya na mas naglala pa to sa na situation, like sa iyang work dito nawala ang iyang ang iyang pandemic. So tungod dato nagpaano siya, then nahulog siya sa apportion liability, which is nakuha nimo or na-harm ka sa yung ginasudlan na bagay or related ka dito ng situation. And next is tungod dato mahulog siya sa court, di ba? And dagan pag employers na nagreklamo to during the case, like, may mga various level pod sa noises na sila gid affect og maayo. And tungod dato mawala ang mga hearing nila, and while katrabaho sila mas galala o dito na situation. And very na case kay na okay siya but nahulog siya sa apportion liability and dapat sa company po may dapat sila gud kanang kablos lang magano silang mga employee tanaw gud sa kana na situation. Halimbawa kung enough ba ang proper na ilang gamit para silang work or may madawat ba silang employee or silang ginay mo sa employee is okay ba, di ba to? So mo lang to.
So Irs8 Hunter Shipbuilders Ltd 1982 1 AER 264. The provision of safety instructions to both employees and non-employees. So this case was brought by the HSE following the deaths of 8 workmen on board HMS Glasgow in 1976, which was being fitted out Swan Hunters shipyard in Newcastle upon Tyne at the time. So this case was brought by the HSE following the deaths of 8 workmen on board HMS Glasgow in 1976, which was being fitted out Swan Hunters shipyard in Newcastle upon Tyne at the time. So the outcome of this case was the sub-contributors Telemeters Ltd was fined €15,000 and the main contractor Swan Hunters Ltd €3,000. So Irs8 James Whitson and Corporation Ltd 1952 2 AER 192 dermatitis from wood dust. The plaintiff constructed dermatitis as a result of exposure to the wood dust and claimed damages for breach statutory duty under Section 4 and Section 41 of the FA 1937, now 4 and 63 of the FA 1961. The Court of Appeal that there had been no breach of 4 as this section only the ventilation, not to other methods of rendering dust. The dust was not offensive to those employed, and accordingly there had been no breach of Section 47 either.